Okay. Good morning, good evening, good afternoon. Let's see if we are going live. It does appear that I am live now. Awesome. Okay, so I'm live. I've been looking forward to today for quite some time. Uh, Finally, a chance to really see A. Blair Dunn in action. I was hoping it was going to be, what's her name? Delphine? Let's see. It was the gal who was writing all of the opposition briefs was Jade Delphin. Terrible attorney, or at least on paper. Nothing I've seen about her has made her a good attorney. So today was the oral argument. There's a link in the description of this video if you want to see it. My understanding is they will take it down, and you'll have to go to, let's see if I can fix that so you can see. No, I don't want that. Damn it! I want to move this. No. Just for gosh goodness sakes, Grinzing. It's like that. I'll move me down into the corner. And then when I'm on this, there we go. So now you should be able to see the link for the oral argument download. The obviously today's the 11th, 9/11. Happy Twin Towers Day. And was a thing that I could do to pop out. I used to be able to have the chat up, but I guess is she as good as Darcy? Asks Nasty Nate. Well, she didn't file a nonsense amicus brief, so I can't tell you. But anyway, so I've been waiting for this for quite some time. This was going to be me seeing if maybe A. Blair Dunn's associates were just the terrible ones, and maybe he was going to pull some aces out of his back pocket and really impress us. Just for the record, I did close my office door and listen to this while I worked today, so I have heard it before. And let me just say that one of the first things that you really need to do if you're going to be making an oral argument or opposing an order of a judge is actually have some familiarity with what the court ordered, have gone through, looked at the citations that the court made, and essentially what you want to do is you want to have good reasons why the things that the court said are wrong. So for example, you shepherdize all the cases that the court cited, looking for new cases that may have overturned them, clarified them, brought them into question, what have you. So you really want to be prepared. I don't listen to a lot of oral arguments at the appellate court level, but occasionally I listen to them, and generally speaking, it's the U.S. attorneys that are really good at this, and generally speaking, private counsel not so good, and that's probably to do with private counsel oftentimes has the worst arguing position, but oftentimes also private counsel maybe doesn't have as much time to devote to prepare. But you want to be able to anticipate what the court's going to ask. And the best way to anticipate what the court's going to ask is to look at what the district court said. The district court said this is a problem. Well, guess who also is going to say it's a problem? The Court of Appeals. Because the Court of Appeals is looking for why you think the district court was wrong. So they're going to say, hey, basically the district court said X. You want to be able to answer why X is wrong, right? So you'd think he would understand judicial and quasi-judicial immunity. Now, remember when I went over this order, I didn't understand why she was talking about it, but that's neither here nor there. You want to understand why She talked about declaratory relief based on past liability is not something that she could grant. You want to be able to understand why she said that, and you want to be able to understand why maybe she's wrong. I don't think she's wrong, but you want to have an argument ready for that. You want to understand why she said individual capacity claims for prospective declaratory relief are not allowable. You want to understand that. And then you also want to understand the 11th Amendment immunity for the state. You want to understand it. You want to look at the things that she cites and understand if those citations are good, if they're bad, if you could distinguish them, etc. Right? That's how you'd prepare. So without much in the way of further ado, we're going to jump in. And yes, I am going to stop this a lot. If you want to hear it without me stopping it, the link's in the description.
May it please the court? I'm humbled.
Normally you would introduce yourself at this point, Mr. Dunn. There is no bourbon tonight. I did have a beer earlier. I'm making a pork stew and didn't use all the beer, so I got to have me a beer tonight. Now, normally it's too carby for me. But waste not, want not.
By the opportunity, or rather the honor and the privilege of discussing a First Amendment case in light of the events yesterday in Oregon.
Now, what he's referring to here is the Charlie Kirk shooting, which is a tragedy, whether you agree with him or not. For all of the liberal outrage, he was a moderate. Most liberals think, and I know I'm placing myself out on a limb here, and I'm going to get half of my audience telling me how I'm a Nazi, and that's fine. I am to the right of Charlie Kirk. He was a moderate, and no one deserves to be shot. I mean, he was a moderate who was willing to use the First Amendment to take on the ideas of people he disagrees with. The court audio is low. Court audio is low. It's max. That's all I could do for you, brother. You're gonna have to turn it up or turn me down, or I could turn me down and you could turn the court audio up. Hold on a second. Let me just play it for a minute.
I mean, Utah. I'm sorry.
I could do this.
I think about the.
Let me know if that fixed it for you, WTT. I am recovering from a cold, so if I cough a little bit tonight, you'll have to forgive me. But this leftist idea that everybody to the right of them is a Nazi is pretty annoying, and leftists celebrating the killing of a man with a family who didn't deserve it simply because he had different ideas from them is also really annoying. And you know what the old saying goes, if you want Nazis, this is how you get Nazis. So, I hope people are understanding that if you keep killing moderates, you just are left with people on the extremes. So good luck to the U.S.
Gravity of that, and I think about the avenues that Mr. Springer was left with as a way of framing this argument for the court.
Now remember, the argument that he has to frame to the court is not the First Amendment argument. The argument he has to frame to the court is why the district court dismissed these things based on judicial and quasi-judicial immunity, on declaratory relief for past acts being a remedy the court can't provide, and based on declaratory relief not being something that you can give if you sue a judge in their private capacity. And just so that everybody understands, if you sue a public official, you could sue them in their public or their official capacity or their personal capacity or individual capacity, depending on which court you're talking to and how they want to frame it. If you sue them in their official capacity, you can sue them for declaratory relief. A declaratory relief suit is an official capacity suit, or an injunctive relief suit is an official capacity suit, because the relief that you're requesting is something that they can only give you in their official capacity, right? Woodford Reserve Limited Edition. Oh, well, send me a bottle. I'll try it too. Private or personal or individual capacity is different. That's where you're saying you did such a bad thing that you, Mr. Government official, should have to pay me for it, right? Uh, and the generally speaking, the state government, local government, county government, what have you, isn't responsible for picking up that bill. You're actually suing that person, right? As opposed to suing. So if you sue someone in their official capacity, you're actually suing the entity that they are working for, the state, federal, or I'm sorry, the state or local or county government that they work for. It's it looks like you're suing the person, but you're actually suing the entity that they're working for. So if you sue like a police officer in his official capacity, you're suing the city. If you sue a police officer in his personal or individual capacity, you're suing the actual individual police officer, right? So, like for example, the reason why they normally sue police officers in their individual capacity is because you want money. Um, and the only way you're going to get money out of the city is if you attach a Manel claim. So if you so you can either sue the city or you could sue the police officer in his official capacity. You'll still have to prove the same thing. You'll still have to prove the Manel claim. It's two ways of saying the same thing.
When we're discussing, of course, absolute immunity for the judiciary, I want to first acknowledge the very real inherent authority and needed.
And by the way, it was a risky maneuver for him. I think A. Blair Dunn is politically blind enough that he doesn't necessarily understand that Charlie Kirk is a divisive figure. And he may or may not understand that a lot of the judiciary, especially the federal judiciary, is appointed by Democrats. You have to remember, Biden was just in office. So a lot of the judiciary has been appointed by Biden. Obama was in office for 8 years. A lot of the judiciary that he appointed is still in office. So he may be talking to justices. In fact, in Denver, Colorado, there is a statistically significant probability that he's talking to justices who don't share his ideological opinions. And that is one of the many reasons why I would never lead in my complaints and things like that with as much political material as he does. If you remember his complaint, he was talking about the Federalist Papers and Thomas Jefferson and blah blah blah. And well, that's his style, and every attorney has their style, and reasonable people can reasonably disagree. I'm not saying he's wrong for it. I wouldn't do it because I would not want to potentially prejudice the judge. Now you're going to say, well, isn't the judge supposed to be unbiased? Well, yeah, but the judge is also human. And if it's a wobbler, if it's 50-50, the judge thinking, well, that attorney's an asshole might be enough for the judge to say, well, all other things being equal, this guy's an asshole. He likes the Federalist Papers, so I'm going to. Oh, sorry about that, Media Watch. You can always watch this later. Remember, I don't put ads in it. So just that's just one of the many criticisms I have of him, and he may disagree with me. He probably does.
Authority of the court to maintain decorum and to maintain order and to maintain the efficiencies going on before the court. That's of course there. And the ability of the court to address anything that interferes with those through contempt powers. I think that those are things that are important to note.
How does this address anything in what the district court magistrate said?
I think what's different about this case, and I would immediately go to, is that Mr. Springer didn't, at least in the later stages of this, when the administrative orders were coming out, when he was being kicked out of proceedings as a member of the press.
This dumbass is arguing the merits of his fucking case right now. He's not actually arguing the decision the magistrate made in dismissing his complaint most of it with prejudice, terminating all but one. So what the magistrate did is the magistrate terminated all the parties except for the one judge, and she dismissed with prejudice all of the requests for relief he made except the request for prospective future injunctions, right? Because She said that you can't do a past declaratory relief for past things, but we can do stuff for the future if you plead it right. And what he has to plead is that under 42 U.S.C. 1983, he has to prove that either there was declaratory relief that the judge is ignoring, a declaratory decree was violated, or he has to allege in his complaint with sufficient detail that it's plausible that declaratory relief is unavailable. So and she even said in the order dismissing the complaint, she said, like, look, if this is your last shot, I'm not going to give you any more amendments to the complaint. So if you come at me, you better come right. And those are the two things that he's going to have to plead, that either there was a declaratory relief decree that was violated, or that declaratory relief is unavailable, in order to be able to sue her in her official capacity and potentially prevail. So that's his only out at this point.
From a virtual proceeding and then was barred from a proceeding in front of Judge Murdoch, wasn't engaged in disruptive behavior inside of a courtroom at that point. And I think that's an important distinction that we point to, and of course in light of Cohen, as really indicative of where this case is.
Like, where this case is. Where this case is dismissed, mostly with prejudice, but slightly without prejudice. And your job right now, Mr. Dunn, is not to argue the merits of your case. This isn't a trial court. This isn't family law. Your goal here is to convince the Court of Appeals the district court magistrate made a fucking mistake in dismissing it.
There's no doubt, and I'll acknowledge that Mr. Springer's rhetoric outside of the courtroom, and
there's no doubt, which means clearly, by the way, clearly,
in a social media medium, was caustic. He uses language that I'm quite certain would inflame the absolute average person.
This part is so frustrating to me. Just remember, all of these are timed. I don't remember exactly how long you get. I think you get about 15 minutes aside, right? So he has 15 minutes because his pleadings didn't do shit. His pleadings were absolutely fucked up. But he has 15 minutes to convince the court the magistrate was wrong, and he's blathering on about the merits of his fucking case. Very irritating for me.
And I'd like to note something that is not really part of the record, but I think bears mentioning. We've harped on the idea that if the court really needed to address his lack of decorum, his lack of not interfering with the process, that would have been squarely within the court's contempt powers, even outside of the courtroom. And there was a contempt proceeding initiated. This doesn't show in the record because it never became involved in the...
All of this is completely fucking useless prattling.
In this case, in the course of the proceedings. But that ultimately was sent to the New Mexico Office of the District Attorney for prosecution for contempt, and it was in front of a judge in the 13th Judicial District, away from the 7th Judicial District, and ultimately was dismissed by the prosecution, nolle prosequi, for lack of evidence. And I just want to emphasize that. If the court really needed to get a hold of Mr. Springer...
No, he's not racking up billable hours by doing this. He's only got like 15 minutes. I'm pretty sure it's 15 minutes. Each one of these is about a half hour long. So if you've only got 15 minutes to present your case, why not actually, I don't know, say something that has merit, say something that might actually persuade the judges that the district court was wrong? Seems reasonable to me.
The court had the ability and the inherent authority to do that, and did look at doing that. But what you have instead are these administrative orders and these actions by the judiciary to just boot him from the proceedings. And at that point, that's why I think this is important, because, well, I'm sorry, Your Honor. Because the only avenue of appeal, looking at the pre-deprivation and post-deprivation taking away of his rights, the only avenue he had appeal to appeal the actions of the district court and the folks that we've named here is this court. It's ultimately this case, rather.
Yeah, but you didn't fucking plead it right, you numbskull. You didn't fucking plead it right. So convince the court you pled it right. The district court said you didn't plead it right. convince them you pled it right.
Your Honor,
So you're addressing merits, but you've got some real procedural problems here, don't you?
I think that there.
That seems to me probably keep us from addressing the merits of the claim.
Yes. He has to get through the procedural issues. The actual merits aren't in front of the judge right now. Because it was dismissed. It was dismissed on procedural grounds. It wasn't dismissed on the merits. So yes, you have to get the court right now. The Court of Appeals is a court of limited jurisdiction. It can only look at what's in front of it, and what's in front of it is a dismissal based on procedural grounds. That's all it can look at.
Whether there was a First Amendment violation.
As Your Honor, I think you want to discuss the judicial immunity. Is that?
Well, judicial immunity, the nature of the suit being against them in their individual capacities as opposed to official capacities. There are a variety of things here, and I think they're the basis of the Federal District Court's decision. The Federal District Court didn't rule on the First Amendment issue, did it?
No, Your Honor, that's correct. It got to judicial immunity.
If you can overcome the procedural stuff, then
It didn't. It did not base it on judicial immunity. Judicial immunity was one prong that was there, and it was discussed by the court. I think so. My best guess is the district court looked at this like, look, if you're suing them in their personal capacities, their individual capacities, judicial immunity applies, because the only thing you could sue them for in their personal capacity is damages. So judicial immunity applies, even though you didn't say damages, you said declaratory and injunctive relief. And as far as the declaratory and injunctive relief is concerned, well, you can't get that by suing them in their individual personal capacities. So either you're going for damages, money damages, and judicial immunity applies, or you're going for declaratory and injunctive relief, which you could only get by suing them in their official capacities, and you didn't do that. So either way that you try to argue this, you're hosed. So I think this was, in hindsight, I think this was the district court basically hedging its bets, making its order bulletproof, so that it would not be attackable at the Court of Appeals level if, for example, Springer's attorney suddenly said, "Oh, actually, Your Honor, actually, we were looking for damages as well." So
maybe we could send it back for discussion of the merits, but I think you've got a tough road to hoe to get to that.
We had a very narrow road to hoe, Your Honors. I think the way I would countenance that. But I think that there is the opening in that row to hoe under the Supreme Court of Virginia case.
So the Supreme Court of Virginia case, once again, to enlighten the audience, was decided in 1980. After that case, Congress amended 42 U.S.C. 1983, and they added this sentence, or portion of the sentence: injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable, essentially abrogating the Supreme Court's ruling in the Supreme Court of Virginia case. So he's relying on case law, still case law that the district court looked at, and explained. Plaintiff argues the Supreme Court's decision in Supreme Court of Virginia versus Consumers Union of the United States permits him to maintain an action against defense for declaratory and injunctive relief. He's half correct. Judicial immunity does not necessarily foreclose declaratory relief in the appropriate cases, i.e., if it complies with injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable, and if they're sued in their official capacity. Those are the two things he needs to do. And this is the part where he says why, and it doesn't, but where he has to make an argument as to why the Supreme Court of Virginia case is good law, and all of the subsequent law and the amendment to 42 U.S.C. 1983 is invalid.
And the court's discussion in that case of addressing prospective declaratory and injunctive relief, which is what we pled for, and we very carefully pled for in this case. And it gets us beyond this being
Carefully pled for, not realizing that the 10th Circuit rules out declaratory and injunctive relief for uh, suits against judges or anyone, any public official, in their uh, personal capacity, their individual capacity. Very carefully pled for, he said. If you were that fucking careful, then how did you fuck it up this bad, dude?
that gets us to this discussion from there of the Judicial Act versus Administrative Act, and the Morales versus Waco and Stump versus Sparkman and some of those other cases. But I think that the Supreme Court of Virginia case gives us that ability to look at not just the court, because the Supreme Court noted both the court and the named justices in that case, and said that and we quoted this in our brief, that there is that opportunity for declaratory relief and
Yes, yes, you did quote it in your brief. And the magistrate looked at it and said, well, there's all of these subsequent cases that talk about the change made to 42 USC 1983 that has essentially abrogated that Supreme Court ruling. So the Supreme Court ruling is great until Congress amends the statute that the Supreme Court was analyzing. Once Congress amended that statute, the prior interpretations of that statute are no longer necessarily valid because the statute is different now. It's like watching a video going over the instruction manual for how to assemble a Colt 1911. Well, if you get a Dan Wesson California compliant 1911, you can watch those videos till the cows come home and it won't help you through it because it's different instructions.
injunctive relief, because this harm was ongoing for Mr. Springer. Those administrative orders and his barring from proceedings continued on. It still continues to this day. Those orders have never been rescinded.
But you can't sue them in their personal capacity. So address how you could sue them in their personal capacity and get that declaratory relief.
He doesn't have any relief other than this case. I think that's entirely what that Supreme Court of Virginia case sets up, is that in these situations where there is this kind of ongoing harm that will go on for forever, of course we need to be able to evaluate.
Just like the Court of Appeals is a court of limited jurisdiction, i.e. it can only take the cases that it has jurisdiction over, and the Court of Appeals gets jurisdiction over it if you meet the procedural requirements, like the issue, generally speaking, has to be a final issue. It has to be a final merit kind of decision for the case. Dispositive is, I believe, the word that they use. You have to fill out the correct forms. You have to be within a certain time frame. There's all these limitations on what the Court of Appeals can hear, and they can only hear the issues that you, number one, preserved below, but number two, raise in your moving papers. Just like that, the district court, the federal district court, is also a court of limited jurisdiction. There's two ways you can get into the district court. Number one, there has to be a statute that authorizes it. Or number two, there has to be diversity jurisdiction, which is a constitutional requirement or allowance. And the way that Springer got this in is because he pled 42 USC 1983. USC means U.S. Code, obviously. So this is a federal statute that allowed him to get in. And the federal court can only hear issues that are properly before it, authorized by that statute. So if he's asking for something that's not authorized by that statute or by some other statute that allows that district court to hear it, well, he's shit out of luck.
Whether or not it does trample upon some sort of constitutional liberty to allow that to continue on using administrative or enforcement authority, which is what they talked about in the Supreme Court of Virginia.
Yeah, but he keeps mentioning this case, but he never explains why it is still good law.
Does that answer your question, Your Honor?
Well, I think you're focusing more on judicial immunity than the restrictions in 1983 on equitable relief, declaratory and injunctive relief, and the question of in what capacity the defendants were sued. But I wanted you to focus on those matters, and we'll see what the appellees have to argue on that point. But I'm not.
Newsflash, the appellees suck on this too.
sure that the merits are something we should be addressing at this stage of the proceeding, when the district court has never addressed the merits.
Your Honor, we did plead that against we didn't plead against the court in its official capacity, I think is part of what you're getting to. We pled against the judges, the court administrator, and the court clerk individually acting under the color of law.
Yeah, that's the problem, doofus. That's the fucking problem.
1983. So procedurally, we did name them, and that's what I was trying to...
Yeah, procedurally, he doesn't even understand the fucking issue, dude. You don't even understand the issue. Although the court finds that counts 1, 2, and 3 also seek prospective declaratory relief to the extent they seek a declaration that Chief blah, blah, blah continue to violate his constitutional rights, they must be dismissed because they are asserted against Chief Judge Murphy in her individual capacity only. Under Section 1983, a plaintiff cannot sue an individual or official in their individual capacity for injunctive or declaratory relief, citing 1, 2, 3 cases. Courts have concluded there is no basis for suing a government official for declaratory and injunctive relief in his or her individual or personal capacity, quoting another case. So there's 4 cases, 2 federal circuit or 2 federal 10th Circuit Court of Appeals cases, a district court case from the D.C. Circuit, and another district court case from the D.C. Circuit. So you have 4 citations in there that all say, and there is a circuit split, just to be fair, there is a circuit split. 10th Circuit isn't, not every circuit follows this rule, just FYI. But in the 10th Circuit, which is where he's arguing, they do follow this rule. And since he's arguing in front of a 10th fucking Circuit court, he should be familiar with the rule. And since the judge laid it out for him in plain language, he should really be familiar with the rule. And he's in oral arguments, and this stupid fuck doesn't even understand what they're arguing about. He doesn't even understand the nature of the issue that he has to make an argument against. He's like, yeah, we sued him in their personal capacity for declaratory and injunctive relief. What the problem is? What a tool bag. I was really hoping that there was some associate that was writing this shit for him, and that he would actually take the time yes, Fletcher boy, if it's outside of the scope of their official duties, if it's like clearly outside the scope of their official duties, and not just official duties, but judicial duties, if it's an administrative issue or something like that, in theory, you can sue the judge for damages in their personal capacity. That is what you're talking about there is a judicial immunity issue. But what we're talking about here is if you sue a judge or any other state actor in their personal capacity, you cannot get injunctive relief, especially in the 10th Circuit. You can't. That's the issue. And this fucking dumbass, when it's his case, doesn't even know that.
And can you get injunctive and declaratory relief against the individuals? You can't, can you?
You can't. You can't, can you? She's coaching him. She's trying to educate him. She's trying to give this stupid fucker a legal education during his oral argument.
And that's all you pled.
I understand that that's the point.
So I don't understand where you're going.
The judge is like, are you fucking retarded? Are you fucking retarded? How stupid are you? You pled personal capacity. You can't get declaratory and injunctive relief. Are you dumb? The answer to that question, by the way, is yes.
Here.
In hindsight, Your Honor, I do understand that we probably should have pled the 1983 against the court, the 7th Judicial District, rather than against the individuals. But we were very cognizant to try to stay away from pleading a Section 1983 claim not for damages.
Yes. See, he still doesn't get it. If you plead the 1983 not for damages, right? That means you're pleading against the official capacity. If you're pleading it for damages, which is what he's trying to stay away from, then you have judicial immunity issues. Excuse me. And he doesn't understand it. He's mixing up in his head judicial immunity and the issue of how you can sue a government official for injunctive and declaratory relief. He did admit his mistake, Fletcher boy. He doesn't understand his mistake. You can't admit it if you don't understand it. That's the problem he's facing. He doesn't understand his fucking mistake. He has no idea what he's doing in here.
That's what we were focused on, to make sure that we didn't run afoul of the Collins case or some of these other cases.
Yeah, the Collins case or some of these other cases that I didn't understand.
That I'm familiar with.
So you really don't have a claim left against the individuals, and you chose not to amend your complaint.
Now, lucky for him or Springer, not that they have any fucking chance of winning anyway. In New Mexico, the statute of limitations for a 1983 lawsuit is 3 years. It's based on the state personal injury statute of limitations for each state, since there's no federal statute of limitations for it. So he filed this in 2023, like mid 2023. So he's got like another year to refile, but he doesn't have a case left.
Well,
You were offered an opportunity to amend, at least to add Judge Murphy in her official capacity. You did not do that.
You done fucked up, son. You're dumb. You made a mistake. You did not do that.
and that's why I point
Trying
to
to figure out what's left here.
why
Aren't we all, sister? Aren't we all?
I'm not sure that I totally agree that we can't, and that's the point of the Supreme Court of Virginia case, and specifically the citation.
He's going back to the Supreme Court of Virginia case. Oh, stupid. Stupid. No clue what he's arguing. Zero grasp of the argument.
That we gave to that and the quote that we gave of that discusses claims against both the court, the Supreme Court of Virginia, and the justices, and specifically the Chief Justice, that they were acting.
You've argued this. You've already argued this. The court heard you, said you're dumb and wrong, and asked you a pointed question about you can't sue them for declaratory and injunctive relief in their personal capacities, right? So there's nothing left, right? Right?
Acting in an enforcement capacity to do that. So it seems to me that, and I understand the court's concern or disagreement with this point, but it seems to me that the Supreme Court of Virginia.
At this point, he understands their concern. No, he doesn't. He's still mixing it up, judicial immunity and the issue of you can't get declaratory relief from suing someone in their individual capacity. He's still mixing it up, so he doesn't understand their concern. He just knows that something's really fucking wrong and he's on the ropes. That's all he understands. It's his lizard brain kicking in. You're fucking losing this. Do something.
The case sets up that you can have a claim against.
And so he goes back to the same goddamn case.
Against the justices for in this case, the judges and the court staff for injunctive relief. For instance,
In their official capacity.
in their official capacity.
Right.
But that's
Which
not how you
you
plead.
didn't plead.
You got two judges chime in. You didn't fucking plead that. You didn't plead it, homie. You done fucked up. You goofed. You done.
We were trying. I don't
We
know
were
exactly how to get.
We were fucking trying, he says. We were trying. No, you specifically pled it the specific way. You specifically pled it on purpose. You went through and you said, we carefully did this. You just got finished saying that we carefully pled this in their personal capacities for declaratory and injunctive relief to avoid the judicial immunity issue.
Get around that, but to say that,
But were you,
for instance,
I thought you were specifically given an opportunity to make your claim against the defendants in their official capacities.
This attorney has done appeals. He's won some, but there's a difference if you're going on the appeal and the law's on your side, right? We'll listen to opposing counsel after this. They're just as bad, but there's no guarantees in life, but 99% sure that they're going to win, not because of the quality of their oral argument, but because the law is on their side. The facts and the law are on their side. Well, in this case, since it's all procedural, the law is on their side. Like, they're going to win by default. So if you ever spend time listening to oral arguments, maybe if you're not an attorney, you won't pick up on it as well, but you'll hear a lot of attorneys with shit cases. And it's not their fault it's a shit case. You play the cards you're dealt, but a good attorney will play the cards well and will understand all of the cases and all the nuances of all the positions, and will try to distinguish all the cases that are against him and try to make cases that appear to be in his favor to sound more like they're in his favor. And we'll have answers to questions, and we'll actually understand the issues that are in front of the Court of Appeals. This is not one of those situations. This is a situation where A. Blair Dunn thought he was going to score a cheap political victory. He was going to sue those judges for James Springer. He was going to get a bunch of attention. I mean, we see this with Randall, right? He was going to smoke these fools, right? Because he didn't understand the law. He didn't understand what he was going into, but his ego outmatched his competency. And he was going to score this victory, and then from this, he was going to get a lot of other clients. All the disaffected people in James Springer's community were going to flock to him, and he was going to be suing judges left, right, and center, and he was going to be rich by God and by golly. And you would think that 2 years and 3 months, approximately, into this, that by this point, he would have a really fucking good grasp of this situation. You say research is the reason appellate attorneys are so expensive. Yeah, it takes a long time to research shit, but this is his case. This is his case from the trial level. He should have known this shit going into it. And you would think that 2 years and 3 months into it, he would have a grasp of at least the basics of this. And he still doesn't.
And Your Honor, we did decline to exercise that because at this point we also had this absolute, for instance, Susan Rosignol, who's one of the court clerks that was at issue here. I think an individual capacity injunction against her is what I'm trying to say that we still had.
No, you don't, because you're trying to tell her not to execute orders issued by a judge. Is what you're trying to do. You're trying to personally enjoin her from executing orders issued by a judge or by some other county official. You can't do that. You've got to actually capture the judge. And by capturing the judge, you've got to capture that court and say, hey, court, you can't do this. It's still an official capacity suit, you dumb fuck. You don't have a claim for relief. There is no claim for relief under a 1983 lawsuit for declaratory relief if you're suing someone in their personal capacity, even if they're just a clerk.
At that point.
When she's acting as a judicial officer, don't you treat her as simply an arm of a judge, an arm of the judiciary, and it's the same rules apply?
I don't know that I agree with that in this capacity. Certainly she's a...
I don't know that I agree with that. Well, what's your fucking legal basis for that? No one cares about your beliefs. What's your basis for that? What opinion have you read that says that? What statute? What have you read? What is the legal basis for that belief?
Clerk of the court, but that's saying, for instance, an example that would be the dispatcher at a police station is not a law.
A dispatcher at the police station is a city employee, just like a cop is. And in order to get them to enjoin them from doing something, you would have to sue them in their official capacity, which means the department gets to step in, because the department gets to control the city, I guess, technically. But the city controls the department. The department gets to control that dispatcher.
Law enforcement officer. And
I don't know why you think law enforcement officers are something special. Law enforcement officers are a government official just like any other Right?
Distinction in her role and the court administrator's role, yes, they are involved in a judicial setting.
Well, did she allegedly do wrong? What did the,
Oh, she denied Mr. Springer services that he was entitled to under state law as a retaliation for his exercise of speech and press on social media.
is that not at the direction of the judges?
No, that's not clear. Not at all. She had some direction about how she could handle that.
Not clear. She had some direction about how she could handle it. So yeah, it is at the direction of the judges. The judges control that courthouse. The judges control that courthouse.
But she took actions, maybe ratified later by the district court, to just shut down the office, to deny him that, and to call. We don't have any evidence that
So they're ratified later, so they're at the judges. I mean, like, you're just speculating at this point.
the judges directed her to call law enforcement. That's not in the record, so we can't assume that she was acting at the direction of.
So if you're trying to enjoin her declaratory relief for her past act of calling law enforcement, good fucking luck on that. We know that's precluded. And if you're trying to get prospective injunctive relief for the future actions of calling law enforcement, again, you can't do that. It's personal capacity suit. Dumb fuck.
The chief judge to go out and call the state police, for instance, or the county sheriff to come down saying that incorrectly and falsely that Mr. Springer was armed, putting his life in jeopardy.
Again, he's arguing the merits. Like, bro, are you dumb? Yes, he is, but like, how dumb are you? You passed the bar, dude. You passed, like, oh. Why do I always cover attorneys that look like idiots?
As we discussed, and exposing him to an encounter with law enforcement, and causing him to be excluded from the courthouse again.
But you weren't seeking damages against her.
No, we just wanted her to.
But you weren't seeking damages. You sued her in her personal capacity, but you weren't seeking damages against her. You stupid fuck. Like, he doesn't even understand. He doesn't even understand the thrust of the court's question.
You're just seeking a declaratory relief and injunctive relief.
Right.
So what were you seeking to enjoin her from that wouldn't be her actions as an arm of the judiciary?
Good question.
To decline her responsibilities under state law to provide records under IPRA.
Yeah. That's yeah. You're basically asking her to do something in her official capacity, you fucking moron. You're saying I'm trying to get an injunction to get her to do her job. What job? Her side job? Her part-time job on the side selling cookies on eBay? No. Her official job. Trying to get her to do something in her official job. Official capacity.
We specifically wanted an injunction that she was not allowed to interfere any further with Mr. Springer's investigative efforts as a journalist to obtain records from the court, which is exactly what she was doing. We wanted her to be enjoined because we had other clerks that were not behaving as she did. So we have examples of Mr. Springer, and they're on the videos. So,
and you don't think that needs to be treated as relief against her in her official?
These justices are so fucking patient. They are so fucking patient. They're really trying to get him to explain why he has a legal basis for injunctive relief against a government official to do her official job as a government official.
Capacity as opposed to personal capacity?
I'm not sure that the distinction merits the dismissal that we received, and that's what.
It does. It fucking does. It literally does. You're precluded. What part of that don't you get, you thick fucking skulled moron?
What we were getting at is that these actions should have been put against him.
By merits, maybe not on the merits, but the procedural precedent is.
The judge keeps trying to bring him back to the procedural issue. You've got a fucking procedural issue, dude.
As argued by the appellees, requires that claim for injunctive or declaratory relief be made against a defendant in the defendant's official capacity.
And if the court would, I would point the court to the order from the district court that we decided not to amend under. She didn't invite the amending of the claims against everybody else. The only claim that I recollect that she invited was one against Judge Murphy. So she's wiping out those other claims against those other individuals. That was another reason we didn't think that there was, she only said that she would allow amendment as to Judge Murphy.
And is that because they were futile? They would have been futile in their official capacity because of the immunity?
Maybe.
And because you can get all of the relief you're requesting, assuming that you could meet the statutory basis of showing that that the Seventh Judicial District Court violated a declaratory decree, or the declaratory relief is unavailable. Then you can get everything you're looking for. You can get the clerk to give you the stuff you need, et cetera, et cetera, et cetera. You could force the clerk to do her job or whatever the fuck you were trying to do. You don't need to sue them all in their official capacity, because once again, official capacity is essentially, if you're going for damages, official capacity is the same thing as a Monell claim. Otherwise, you still have to plead basically the same thing as a Monell claim. You have to say that like this custom practice, whatever, blah, 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 right? But essentially, when you're suing the official capacity, you're suing the entity, even though you're naming her. He's wanting to retry the case at the appeals court. Yes, and he's doing a terrible job. I've seen family law attorneys make better arguments than this.
I could speculate that that's why the court did that, but the problem with that is still that
I could speculate that's why the court did that. Yeah, no, that's why the court did that, you stupid retard.
you have, for instance, Susan Rosignol and the court or the court administrator, you have these other claims. Why wouldn't we be allowed to, those wouldn't be futile if we brought them in their official capacity.
Yeah, they would, because you'd be seeking declaratory and injunctive relief from the 7th Judicial District Court. Or is it the 6th? 7th. It's the 7th. 7th Judicial District Court. Every person that you had an issue with was an official of the 7th Judicial District Court. And the 7th Judicial District Court is the one that can basically give you all the relief you're requesting if court orders it.
I think the court could agree with me on that point based upon the
I think the court could agree with me on that point. No, it can't, because you're dumb.
colloquy we just had. So why couldn't we have been able to amend to bring those claims against them? Still, there's no finding of futility other than there's this judicial, which is why I led with the
So all of the stuff regarding the declarations of the past decisions are futile because they're seeking a declaration of past liability. And oh yeah, an order barring an individual from entering the courthouse or courtroom is a judicial act. Yeah. Where did she get into? So Murdoch Poff is a judge. Jason Jones, I think, is a head clerk. Susan Rosenthal is a clerk. And then the 7th Judicial District Court was terminated from the action based on the 11th Amendment immunity issue, because the state law that granted the ability to sue, the Tort Claims Act, requires the suit to be in state court, not federal court. So yeah, why does he need to add them? They're terminated because they're redundant.
argument about judicial capacity. But you still have that, right? You'd still have those claims against those folks, and then you would have to do the analysis.
But see, here's the thing he's not getting. It's not claims against folks. If you sue them in their official capacity, it's not claims against folks. It's a euphemism. You're actually suing the entity. It's it's like a it's like a it's like fiction. If you sue the Secretary of State in his official capacity, then the state of California would be the one who would be on the hook, essentially. You don't have to sue the Secretary of State in his official capacity, the Deputy Secretary of State in his official capacity, an assistant to the Deputy Secretary of State in his official capacity, or her, whatever. You get what I'm saying? Like it all of those would be just the state of California if suing in California. All of those would just be the state. They would all be the state. You'd just be naming the state in three different ways.
Whether or not they got quasi-judicial immunity. And then we get from there, and just very briefly, because
if you're seeking declaratory relief, judicial immunity really doesn't apply, except for the portion that says that there has to have been a declaratory decree that was violated, or there's no opportunity for declaratory relief.
I only have a little bit of time left. We get to the 11th Amendment immunity argument, and I have real trouble with that. It feels to me as though... What kind of a upset girlfriend argument is this? It feels to me. Like, what does the statute say, you stupid idiot? Especially after the colloquy I just heard in the other case. At a minimum, there was supplemental jurisdiction that upon the dismissal of federal claims...
It wasn't a supplemental jurisdiction issue. It was an 11th Amendment issue. It was a state sovereignty issue. You idiot. You idiot. You blithering buffoon.
Should have warranted...
Why do I know his case better than he does? Imagine that. Imagine that. This guy's been living this fucking case for 2 years and change. And some shitty family law attorney in California, a first-year family law attorney in California, knows the fucking case better than he does.
Dismissal without prejudice of those claims, but the court went further as if to seal those off and to make it so that we couldn't go forward in state court by granting 11th Amendment immunity.
The 11th Amendment immunity, the only...
Can't go forward in state court with 11th Amendment immunity. What kind of a fucking moron is this? The 11th Amendment precludes you suing the state that you're in federal court. That's what the 11th Amendment does. You can sue the state you're in the state as long as the state grants you the right to sue them. The state grants you the New Mexico Tort Claims Act, or whatever they want to call it, so that you can sue them under certain circumstances as long as you do it in state court. By saying the 11th Amendment precludes the suit in the district court, it says nothing at all to do with what you can do in the state court. Nothing at all.
The preclusive effect that would have is precluding you from bringing this claim again in federal court.
In federal court. The judge has to explain it to him because he's a fucking moron. He doesn't even, like, holy mother of God.
When the decision is to dismiss claims because of 11th Amendment...
They're literally having to teach this guy the law. The justices are literally having to sit little Timmy down and say, look, little Timmy, this is how the 11th Amendment works. Don't know where you passed the bar. Don't know how you passed the bar. But let me explain how the 11th Amendment works.
Immunity, that does not preclude you from proceeding on the same claims in state court.
Yes, but
Maybe you're precluded on other grounds.
But it's completely unnecessary, and it colors where we go from there. We didn't want...
But it's unnecessary. So just ignore what I said earlier. It's just unnecessary. Yes, it is necessary because the 11th Amendment is in the fucking Constitution. Oh, you stupid idiot. It's really fucking important because the 11th Amendment's in the Constitution. There's nothing more important at the federal level than the Constitution, than the United States Constitution.
I want that to be the last word on that. Why the district court weighed in and said that there wasn't...
It would be the last word on what the 11th Amendment means, and that's the sort of thing the federal court can decide.
He's having to explain this to a fucking attorney. This hurts my soul.
It's not a matter of state law.
It is, but I think the federal court decided that incorrectly, which is why we're here. I think the
It will explain why. Explain why. Show me the fucking law that says they decided it wrong.
state has clearly waived sovereign immunity
Okay,
It's clearly waived sovereign immunity. Well, let's go through it.
and 11th Amendment immunity.
that's before our court for sure.
Well, that's what I was getting to, Your Honor. I'm
Okay.
sorry. Yeah. No, that's my point, is that the state statute, specifically under the Civil Rights
Specifically,
Act, waives sovereign immunity. So the court is just wrong on the 11th Amendment argument, and that's why we're here to address that.
Let me ask you, the state statute doesn't specifically say that this immunity that's waived can allow suits in federal court. It's not enough that it's waived, that the state has waived sovereign immunity with respect to claims against it. It also has to say, we don't mind your bringing those claims in federal court. And the
it's fucking school time for Timmy here.
Supreme Court has said that's got to be crystal clear in the state statute, or whatever the state law is.
The Supreme Court said that. Uh-oh. Uh-oh. What's your argument, Mr. Dunn?
How do you overcome that?
I don't know that I disagree. I would agree that it's not crystal clear that the state is intending those claims to be certainly brought in a state district court.
Yes.
Yeah, it says that specifically.
It says it can be brought in the state court. This is not the fucking issue, but it says it can be brought in the state court. Yeah, but you're here right now because you're saying that the district court got it wrong when the district court said that it could not be brought in a federal court. What an idiot. What an idiot. Completely unprepared for this.
That's crystal clear.
But the statement that there is no sovereign immunity and they can't raise that defense seems to preclude an 11th Amendment defense.
Well, there are different types of sovereign immunity. There's sovereign immunity within the state court, which is waived, but that doesn't resolve whether that claim can be brought in federal court. And the Supreme Court, you have a decent common sense argument, but I don't think that's...
That judge is being so nice. You have a decent common sense argument. Judges aren't there, or attorneys aren't there to make decent common sense arguments, especially on procedural issues. Procedural issues are pretty cut and dry. There's a statute. It says in order for us to hear this, you have to do X, Y, and Z. So how do you get around that? Well, you do X, Y, and Z, or you find a better authority that says you don't have to do X, Y, and Z. Dunn did neither.
The way the Supreme Court has addressed it.
Fair enough, Your Honor. Then I will leave it that there is that common sense argument that statutory interpretation in New Mexico, that's about as close as we're going to get the legislature.
Okay,
So
thank you.
thank you, Your Honor.
I don't know that I understood what you just fucking said.
Fair enough, Your Honor. Then I will leave it that there is that common sense argument that statutory interpretation in New Mexico, that's about as close as we're going to get the legislature.
Okay.
So
Common sense argument that in New Mexico, that's about as close as... Wait, just, Well, I'm done. I'm not going to suffer through. Garcia was just as bad. He was just as bad. He offered nothing new that the district court didn't already offer, much more concisely, much better stated. So Garcia was pretty terrible, but Dunn, like, you're done, Dunn. You're done. So Close saying, I'm late to the party, business lawyer suing everyone on copyright claims. No, that lawyer has shown a basic level of competency. I don't like him, but he's shown a basic level of competency. I can't really, I apologize for snorting. I can't really dig too hard on, other than the fact that he relies too much on AI for his briefs. And he doesn't do very good research. Dunn is incompetent. Like, all I could say is I have seen nothing competent out of him in this case. Maybe in other areas of the law he's great, Maybe he has a really great grasp of something. But in this area, he was way out of his element. He didn't realize he was way out of his element. He had too much pride, too much hubris. I'm assuming that he thought he was going to draw a lot of Springer's clients to get rich off suing the judiciary. Because remember, he went in asking for damages. He went in asking for damages. Now he realized that that was a loser, and excuse me. So he backed off. I'm gonna have to go below my nose here in a minute. So he backed off and switched to declaratory relief. But right now he's just thrashing around, trying to save himself in a sinking ship, and it's just going down. So anyway, with that said, thank you very much for watching. I'm going to stop leaking on camera and go blow my nose, and have a wonderful, wonderful day.